In the matter of Serious Fraud Investigation Office versus ADITYA SARDA, Supreme Court allowed certain appeals while dismissing appeals arising out of SLPs of Akshat Singh, Naveen Kumar, and Mahesh Dutt Sharma. The respective impugned orders dated 29 March 2023 and 20 April 2023 passed by High Court granting anticipatory bail to concerned accused who were respondents in these appeals were set aside. So respondent accused were directed to surrender themselves before special court in 1 week from today. Also, their bail applications, as and when filed by them, would be decided by special court in accordance with law. In the instant case, special court considering seriousness of alleged offences had initially issued bailable warrants. However, respondents kept on avoiding execution of such warrants and did not appear before special court, though fully aware about pendency of the complaint proceedings against them. Special court therefore had to pass detailed orders from time to time for issuance of non-bailable warrants and thereafter had also initiated proclamation proceedings under section 82 of the code for requiring respondents to appear before it. High Court, without paying any heed to proceedings conducted by special court against respondents and ignoring well-settled legal position, granted anticipatory bail to respondents. Court stated that orders being perverse and untenable at law cannot be allowed to be sustained and deserve to be set aside. It said that it is no more res integra that economic offences constitute a class apart, as they have deep rooted conspiracies involving huge loss of public funds, and therefore such offences need to be viewed seriously. They are considered as grave and serious offences affecting economy of the country as a whole and thereby posing serious threats to the financial health of the country. The law aids only the abiding and certainly not its resistance. When, after investigation, charge sheet is submitted in court or in a complaint case, summons or warrants are issued to accused, he is bound to submit himself to authority of law. If he creates hindrances in execution of warrants or conceals himself and does not submit to authority of law, he must not be granted privilege of anticipatory bail, particularly when court taking cognizance has found him prima facie involved in serious economic offences or heinous offences. In such cases, when court has reason to believe that person against whom warrant has been issued has absconded or concealing himself so that warrant could not be executed, concerned court would be perfectly justified in initiating proclamation proceedings against him under section 82 of CRPC. High courts should also consider factum of issuance of non-bailable warrants and initiation of proclamation proceedings seriously and not casually while considering the anticipatory bail application of such accused. In the instant case, Ministry of Corporate Affairs had directed Appellant SFIO to investigate into affairs of 125 companies, and on completion of investigation, SFIO had lodged private complaint before special court against accused, including the respondents alleging various serious offences under Companies Act, including Section 447 and offences under IPC. It is pertinent to note that as per subsection 6 of section 212, offence covered under section 447 of Companies Act had been made cognizable and person accused of the said offence is not entitled to be released on bail or on his bond unless 12 conditions mentioned therein are satisfied. The twin conditions are that a public prosecutor should be given an opportunity to oppose the application for such release, and where the public prosecutor opposes application, court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and he is not likely to commit any offence while on bail. These twin conditions are mandatory in nature. Though special court had taken cognizance of alleged offences under Companies Act, including Section 447 and other offences under IPC, even though non-bailable warrants were issued from time to time against respondents, and even though proclamation proceedings were initiated against them, High Court had passed impugned orders. Said orders have been passed in utter disregard of mandatory conditions contained in Section 212(6) of Companies Act and also ignoring conduct of respondent accused. Such orders being teeth of legal position settled by the court as also teeth of section 212(6) of Companies Act would fall into category of perverse orders, therefore untenable at law. In a recent case in Union of India through Assistant Director versus Kanhaiya Prasad, it has been observed by Supreme Court that cryptic orders granting bail without adverting to facts or consideration of such restrictive conditions with regard to bail are perverse and liable to be set aside. Granting anticipatory bail is certainly not the rule. Respondent accused who have continuously avoided to follow due process of law by avoiding attendance in court, by concealing themselves, and thereby attempting to derail the proceedings would not be entitled to anticipatory bail. If the rule of law is to prevail in society, every person would have to be abide by the law, respect the law, and follow due process of law. It cannot be gainsaid that judicial time of every court, even a magistrate court, is as precious and valuable as that of high courts and supreme court. Accused are duty bound to cooperate the trial courts in proceeding further with the cases and bound to remain present in the court as and when required by the court, not allowing courts to proceed further with cases by avoiding execution of summons or warrants, disobeying the orders of the court, and trying to delay the proceedings by hook or crook would certainly amount to interfering with and causing obstruction in the administration of justice, said Supreme Court.